guys, welcome. I'm sure you enjoyed the introductory video where we explained the whole concept of immovable property. I think we distinguished between what movable property was and what immovable property was. And I explained to you briefly the purpose of this series of lectures, or the law under immovable property, and what we're going to look at. Now, in this lecture 2, we're going to discuss first what land is. What is land? We'll try to understand what land is. Okay, and the other things that make up land. That way you will try to get the sense of what all the various components and how the law applies, if you know what land is. So we'll discuss that. We'll talk about a very important aspect of land, immovable property, like when we mention land. That is what we call the fixtures and chattels. Some people prefer to call it chattels. I don't know, because of its French origins, but you can, anyway, that's convenient for you. You can either call it chattels or chattels, if that's okay. So fixtures and chattels, what are they? How relevant is it in your understanding of immovable property? And why is it necessary? For you, in practice, why would the difference between a fixture and a chattel be of importance? So this and many more we are going to discuss in this whole series of this video of lecture 2 in What is Land? Now, what is land? What is land? We refer to a very authoritative dictionary, the one that we call the Black's Law Dictionary, right, by Bryan and Ghana. Now, the 9th edition, this is the definition of land. Let's see. Now, the Black's Law Dictionary by Bryan and Ghana, or the 9th edition 2009, defines land as an immovable and indestructible three-dimensional area consisting of a portion of the earth's surface, the space above and below the surface, and everything growing on or permanently affixed to it. You got the definition? All right, so let's try and just see if we can just remember some of the key aspects of that. Now, we mentioned that in the definition that we saw from the Black's Law Dictionary. When we talk about land, we are referring to the space on the earth's surface. So it could be the topsoil, what you see, what you walk on, what you drive in your car. So that space we can call a land. It can also refer to the things that are below the surface. So if someone digs into ground, that space below the obvious surface is also part of land. I'm sure in your house, some of you choose to plant cocoyams and plantains and other stuff. What do? You dig and you put it in there. You have the right to do that because that space below the surface is also part of land. That's what the definition says. Then it also mentions the space above it. The space above. So if you're at home, right, or whatever premises where you reside, the space above just the surface, it is also part of what we call land. So it may include the water body that you may have around and all that. It's all part of land. Now, one other authoritative writer, professor, Sir Dominic Dennis J, in his landmark book, Land Law, Conveyance and Practice, had this to say. He cited a very authoritative story or case from the common law or from the English jurisprudence. And we have the opportunity of looking at it. Let's take that case from Sir Dennis J's book, page 2 of his Land Law, Conveyance and book. He referenced Kelson versus Imperial Tobacco Company, 1957 Kills Bench. Now the text says that the defendant's advertising board encroached onto the space barely 8 inches above the plaintiff's ground level. The court held that the defendant had committed trespass. You saw the case? Yes, that was cited in approval in Sir Dennis' books. Now it says that this person had put an advertising board. You can talk about it, that advertising board. It could be a banner or anything of such sort, above another person's space, just 8 inches. The court said that it constituted trespass. Now, the point, guys, we have to get from this is that when we refer to land, the space that also comes within your ordinary use above you is also part of what we call land. So if you are living in a house, someone cannot just stick up a rod or something else that just goes above your roof or that just enters into your space. That is trespass. You are not allowed to do that. So when we talk about land, we talk about this space. Now, many times you see many social gatherings are happening in so many places. In some people's houses, they have they've erected all these marquees, what people call canopies, around there. Okay, some of them go about height about 8 meters, 10 meters, etc. You need that space for your comfort. You need that space for your gathering. You need that space for your quiet enjoyment. And therefore, when we talk about land, according to the Black's Law Dictionary definition, it also refers to the space that is above you that you ordinarily have the opportunity of using. What it therefore means is that when you have some space above your land, that does not come within an ordinary use, that does not allow you to reasonably extend access and use it, can you call that land? Now let's refer to another case that speaks about this kind of reasonable use of spaces that are above you. So the case is Bernstein versus Skyviews and General Limited. Now it says that the defendant flew over the property of a claimant and took aerial photographs. The court held that trespass was not committed because the landowner's rights extend to a reasonable height above the property. So you saw that. So this person, according to the facts, flew over someone's house and took aerial shots. And the matter went to court. When the matter went to court, the claimant, when I say the claimant, I mean we are referring to the person who felt that his space had been trespassed. Someone had entered onto his land by flying over his land, his area of view, and taking shots over it. What did the court say? The court said that where the person took his shots does not come within the reasonable height of your use. What it therefore means, if you put together the case of the Bernstein views and the Kelsen case, what it means is that when we refer to land, the space above you refers to the space that comes within your ordinary and reasonable use. Your ordinary and reasonable use. Guys, you get that? So if the part that you are claiming to be your land does not come within your ordinary or reasonable use, that land is not yours. That is not part of your land. So if someone should fly about 100 feet above you, okay, or something like that, any other unreasonable height, a height that you yourself cannot reach, even if you have a ladder, that does not constitute land. So in this part of our discussion, we've tried to explain what land is. Now, if you're a student, it's important that you take note of this definition that was given in the Black's Law Dictionary to understand the scope of land. We are saying the area on the topsoil, okay, the space below it, and the space above it. The two authorities that we've mentioned have tried to delimit what we refer to the space above as the ones that come within our ordinary and reasonable use. So the height should be within your ordinary use, and the height should also be reasonable. Anything outside of that scope does not constitute land. Now, the other part of the definition that mentions that the things that grow above it and are permanently affixed to it, that is what leads us to the next aspect of our discussion: fixtures and chattels. So what are fixtures? What are chattels? Let's look at that aspect of land where we talk about fixtures and chattels. Okay, so the definition which is still binding us and guiding us in our discussion is what we took from the Black's Law Dictionary, where we are saying that land may refer to things that are below, above. Now, the more important aspect that fits in here, which we've just mentioned, the fixtures and chattels, is you see that the things that grow on the land or the things that are permanently fixed to the land. Now, guys, here's it. Maybe you were interested in purchasing some land. So you went there, the person showed you the land, and you found some items, maybe an old truck, okay, an old truck that had probably been dumped that had been packed on the land. Or let's say there were some cement blocks or stones or anything of the sort. If you buy that land, now the question is that those concrete blocks, those cement blocks or the concrete blocks, that old car that is parked there, does it belong to you? Is it part of the land? Or let's say, for example, when you purchase a land, there are some other economic trees on it. When I say economic trees, these are trees that probably you could sell their produce. Maybe there is pear, there is mango, there is orange, things like that, things that are of some commercial value. Those ones, if you purchase the land, do those items belong to the original landowner or it now belongs to you? Or let's say even you go and rent a house or you buy a house. Now you went for an inspection, and when you entered the house, you saw so many things. You saw chandeliers, you saw on pavement blocks all around the yard. There were these nice ornamental plants, and you went in there and there was some kind of upholstery and other nice things, furniture in the room. And you want to buy the house. Now, if you buy the house, or let's even take the other way around, if you are selling the house, the person who buys the house, does he take all the items in there? Or there are some parts of the items that the owner would have to take them out, then the new owner will take over the building. So you see, trying to answer these questions is what makes this area of immovable property that we are discussing of so much quintessence. That is, what do we call fixtures? What do we call chattels? Because trying to distinguish between fixtures and chattels will help you to know what to take when you are buying the land or what to give away if you are selling the land. All right, so what is a fixture? Basically, when we talk about a fixture, we are referring to the things that are permanently affixed to the land, the things that are attached to the property, okay? And when we talk about chattels, we are referring to those things that belong to the owner. They are just objects. So there are things that, for example, if you go to a room and the person has got some light, some ornaments or something else, he can just take it away. But there are other things that may be fixed onto the facility. Maybe he goes there, you have some tiles, some porcelain tiles in the room. I'm not sure if you go to rent out someone's room and the person is going, he has to literally remove all the porcelain tiles on the floor. So these ones that are permanently affixed, usually we call them fixtures. The ones that are easily movable, we call them chattels. So you get that. So basically, the fixtures are the ones that are attached to the landed property, and the chattels are the ones that belong to the owner. They can be moved. Now, the position of the law generally is that fixtures belongs to the landowner. Fixtures belongs to the landowner. So anytime you can categorize an object as a fixture, the person who owns the land takes that object in addition. Chattels don't belong to the landowner. So if someone purchases a property and there's an object that is classified as a chattel, that object does not belong to him unless there has been an express agreement between the parties to allow him to take that particular object. But now, how do we determine, according to the law, what test do we employ so that we know that this is a fixture, that is a chattel? What does the law say as to the ways in which we can determine whatever a fixture or a chattel is? It is important that you know, because if you are an examiner or a student, obviously, probably you are preparing for your entrance exam to the Ghana School of Law, it is important that you try and get this distinction. Because if a question is posed to you, either at your faculty level, end of semester exams, or in the entrance exam, and there is a sale agreement or some sort, and these matters come up, it is important that you know which of the objects are by law considered as fixtures, which of them by law are considered as chattels. Then you know how to deal with them. So let's look at the two-stage test that is employed in determining a fixture and a chattel. The two-stage test was established in the case of Hellawell versus Eastwood. It's an old case, 1851. Now, the test that the court mentioned was 1, the degree of annexation. That is the extent to which the item has been attached or annexed to the property. So you get the first part. So in the Hellawell case, the court established 2 tests. And here's a slide that just flashed on your screen. You saw the first test. We are saying that the degree of annexation. The degree of annexation. When we say annexation, means attachment. So the degree of annexation means that the extent of attachment. To what extent are these objects attached to the property? To what extent are these objects attached to the land? What is the degree of annexation? Generally, that will help you to test whether the object that you are speaking about is a fixture or a chattel. So that's the first test. Okay, let's look at what the second test also says. The second one says that the purpose of annexation, the purpose for which the item was attached to the property. So the second test is the purpose of annexation. The why, the reason why did you attach this property to that? Why did the landowner attach it? Why do you have this property joined to the land? If you understand the reason, it will help us to determine whether it is a fixture or a chattel. Guys, you understand? So it is important that anytime we are confronted, be it in an exam or even in your personal life, you are going to inspect the property. These two tests are necessary for you to understand or determine what constitutes a fixture and what constitutes a chattel. And the test, I repeat, is two. One, the degree of annexation. Two, the purpose of annexation. Let's talk about the first one, the degree of annexation. All right, so when we talk about the degree of annexation, like I've said in my earlier story, okay, we are saying that to what extent do you have the object attached to the land? The point is, or the law generally is that when you have an object that is attached to a higher degree or to a significant degree to the land, because of the level of annexation, the degree of annexation, because it is so attached to the property, it is mostly considered a fixture. That is, it is part of the land. So the one who owns the land will own that thing too. Now, there was an English case, which we call the Ellistone versus Morris case. I mean, it has been authority for so many in the common law field, for so many, and even in Ghana, in our part of the law, you can refer to that, the Ellistone case. And when you go to our website, you have some of these things there, or you can just download it and have a look at it. Now, in the Ellistone case versus Morris, now Morris' predecessor, his grandfather, had bought a wooden bungalow from the claimant, okay? So this wooden bungalow that was purchased, it was fixed onto some pillars. So they had pillars on the land, and the wooden bungalow, like a wooden structure, was fixed onto it. Okay. Now, after a while, the claimant wanted to take that piece, so the matter had to travel to the House of Lords. And what did the House of Lords determine? The House of Lords, that is the highest court in England at the time, and recently has been moved to the UK Supreme Court. The House of Lords said that if we consider the degree of annexation, like if you want to take the object away, is it likely to occasion significant or substantial damage to the land? So once it occasions, it gives rise, it has the higher likelihood and probability of causing damage to the land. That object has got a higher degree of annexation, and therefore it becomes a fixture. So they said that Morris, if they look at the structure, how the structure was fixed onto the pillars, if you want to take the structure away, it means you eventually have, and by necessity, have to destroy the whole pillars. Guys, you understand the concept? So what we are trying to say is that if you have a higher degree of annexation, the way the thing is attached to the property, it is said that if you are taking it away, the property itself will get destroyed. That becomes a fixture. So if someone purchases it, he takes it along. So we can use our common example that we mentioned about the floor tiles and the porcelain. If someone tiles his room, okay, a room is tiled, you go to rent a place or a room and you tile the place up. You take porcelain tiles and tile the whole place with tile cement and all that. And now it is time for you to leave. And you say that you want to take out the tiles. Now tell me, what do you think is going to happen? What do you think is going to happen? Do you think that after we've taken away the tiles, the room will be more habitable? Will it be tenantable? If you give it to another reasonable person, is it likely for the person to enjoy the use of the space? Obviously not, because the degree of annexation, and guys, that's the law, it is so tight that any attempt to take away that will cause substantial injury and damage to the land, and therefore that becomes a fixture. The person who purchases the house, the person who purchases the land, takes that with him. So that is what the Ellistone versus Morris case establishes. Hope you're okay with that. All right, so now let's look at some key points by way of review in what we take about the degree of annexation being a test of what a fixture is. What points do we take? I reiterate these points. The points, like I said, I reiterate is that the key element to look out for is the degree of annexation. To what extent will substantial injury be caused to the land? That is just all, guys, you have to look out for. Okay, so if it is fixed in such a way that an attempt to take it will cause injury to the land, ladies and gents, guys, it is a fixture. It is a fixture. So the person who owns the land owns that fixture. So sometimes, let's say if you are going to buy a property for practical intents and purposes, and there are objects in the room, or even if you have a property, like a house, a land that you want to sell, by this lecture or this part, what we are trying to tell is that you need to determine which of the items do you think you can take away. There are some of them that by law, you may not be permitted to take them away because of the degree of annexation. You know, for example, some people may have installed some kind of lights. These lights, sometimes they chisel the wall and fit the lighting into them. Other people also have inbuilt heaters, okay, for their washrooms and stuff. They put it as part of the construction process. So when the building is being put up, they make provisions for all that and fix it into it. If you transfer that land, you transfer that house, because of the degree of annexation, by law, you cannot take that part away. The person who buys that property takes it alongside with him, okay? So the key thing to understand for examiners or for exam students, I want to say that if, for example, you have in your law entrance exam that you come up that you want to take maybe either in the 2023 edition or subsequent ones, or even in your semester faculty work, and you are trying to assess sales of items in landed property, these are some of the rules that should govern you. We are saying that the first test of the degree of annexation means that are we likely to cause substantial harm or injury to the landed property? Is it fixed in such a way that it gives a certain significant sense of permanence? If that is there, then we are saying that it is a fixture and it belongs to the person who owns the land. If, like we've just said, judging by the first test, where we are saying that the degree of annexation, it means by logical inference, or what we can logically deduce out of it is that if the degree of annexation, okay, how the thing is attached to the property is such a way that it will not cause substantial injury to the property, then it doesn't become a fixture, it becomes a chattel, which means that the person can take it away, okay? Now, there are people, for example, when they build houses, they put these chandeliers there. You know, the chandeliers, sometimes they just hang them. What you may realize is that it has, how do you call it? The electrical socket that is up there somewhere. Then the chandelier itself is just hanging on a hook, metallic hook. I'm sure most of you have seen that. Now, what is the degree of annexation? I mean, if the person is taking that out, is it going to cause substantial injury to the ceiling? Maybe not, depending on the kind of chandelier. So if it is that kind, where taking it away does not cause substantial injury to the facility, it becomes a chattel. The person can take it off. Like ceiling fans. Many people, when you go and rent a room, you realize that there are not even any ceiling fans there. Now, the reason is that it's not so difficult to take down a ceiling fan. You can just put it up. But things like sockets, okay, things like that, what happens? Sometimes if you want to chisel out a socket, you're going to destroy it, okay? So that is just what we need to. Differentiating by the first test, degree of annexation, should help you to determine what a fixture is and what a chattel is. Now, we look at the second test. The second test is what we call the purpose of annexation. Why do you have the thing fitted onto the land or onto the landed property? Why do you have it there? Now, this second test is also important because it is not always the case, and I repeat for students, it is not always the case that once the degree of annexation is not complex, that is, it's easy to take it out, does not necessarily make it a chattel. It may not be that. The purpose of the annexation, even though it may be easy to take down that object, it may still be a fixture. Why? Because when you apply the second test, which we refer to as the purpose of annexation, it will turn a rather easily removable item into a fixture. For example, let's say you are selling a restaurant space to somebody, okay? Someone comes and says, okay, I have a restaurant here and I want to sell the restaurant to you and all that, okay? All right, the person agrees. Say, that's fine. Now, in the restaurant, you have this glass door in front of the restaurant that the previous owner was using. There's a glass transparent door. So that if someone is walking around, the person can see through it, okay? You know the aesthetic value of that. In our modern parlance and part of our country, if people are going around, you don't expect to see a restaurant shut with a solid metallic door. Is that what you expect to see? Obviously not. It has to be, for example, glazed. So that glazing effect, it has some kind of aesthetics. It's able to draw people to want to enter the restaurant and enjoy their food. You understand that? Now, but it's easy to take down that glass. It's very easy to just take it down. You can just get some workmen who just come and they'll just quickly pull down the glass. Now, if the person is selling to you that restaurant space, the question is, that glass door, is it a fixture or a chattel? If you use the first test of the degree of annexation, it is not annexed to the property in such a way that if you take it down, it will cause substantial damage. So you realize that the first test will not work. But let's look at the second one, the purpose of annexation. The thing was put there for restaurant use. So if you are selling the property to another person who also intends to use it as a restaurant, what do you think will happen to the glass? Can you just go and take down the glass? Obviously not. The reason is simple, because the purpose of annexation is for it to enhance its commercial appeal. And therefore, that purpose will disable you from classifying it as a fixture, though it may be easily taken down as a chattel. Guys, hope you're okay. So we are saying that the test of the purpose of annexation is that what was the reason for which that thing was put there? If the thing was relevant, okay, to its previous and even most importantly, its current use, it doesn't really matter, and we don't really care if it is easy for you to take it down. We will still classify it as a fixture. But if in some instances, as it is, what you have there, you can easily take it down, but its purpose is not relevant to the current owner, that can then be called a chattel. Let's look at a very common English case that illustrates this idea that we are talking about. The case is Daincourt versus Gregory, an 1866 case. Now, it says that this case concerned heavy ornamental marble statues of lion resting merely by gravity, so without any installed aids such as boats. In strategic locations, it was held to have been intended to merge with the land, an integral component of an intention to improve the land. So the Daincourt case, as we just saw on the slide, we have these marble of iron shapes, like lion shapes, that were just put there, okay? So it's just all around according to the facts there. What did the court say? The court said that because it was placed in strategic locations, it is obvious that the purpose of annexation was to merge into the land to enhance its fluidity. Hope you understand that. It's aesthetics. So the point we're trying to say is that the Daincourt case, it was not even things that were fixed. Okay, they were things that were just there by their own weight, under gravity, by their own weight, like heavy stones and marbles were just put in there. And the court said that because if you look at how they were strategically located, it would serve to kind of merge into the land. The court said that it was a fixture. It held that it was a fixture. It was not a chattel. So this Daincourt case, guys, students, is helping us to see how the purpose of annexation can help us in trying to settle on the decision between a fixture and a chattel. So please, let's get this. The fixture, first, obviously the things that are attached, that is what we call per se, prima facie, that is what is there. But depending on the purpose of annexation, what may have first been classified as a chattel will now be called a fixture. And that is what this case was trying to help us to understand. All right, so again, let's get the key point in the Daincourt versus Gregory case. The key point is the gravity test is relevant consideration when deciding if an object is a fixture or a chattel. You saw that? All right, so the gravity can help us to see that. But if there's a contrary intention as to it being a fixture, the courts will not hesitate to take it as such. And that is what we mentioned. So anytime we are going to get a property or you are selling a property, it is important that the person who is buying the property and you, the seller, you sit down and you are clear as to the things that he can keep, the things that he can take out. So what are the things that may be relevant to the present user? Even though they may be affixed, they may still be chattels. For example, let's say someone has a house. Now, in the house, he had an old car, okay? You know, there are some people who like vintage cars, like 16th century, 15th century, and sometimes they just park the car somewhere in front of their houses or a space and just keep it oiled. So like an attraction, someone enters and says, wow, that's a nice car you have there. oh, this was an 18th century Mercedes, this was a Volkswagen, and all that. People are interested. So the person, because of his aesthetic taste, keeps it. If I go in there, or you go in there to go and buy the house, the question is that the purpose for which that object was there, do you still need it? Are you a car lover? If you do, that car may be the reason why you bought the house, and therefore, though you can move it, it still becomes a fixture. Because the purpose of annexation is to still enhance its aesthetic feel or that cultural element in there. For example, someone is a traditional ruler, a chief. He wants to go and buy a house. Now he goes into a property that is shown, and he goes there, and there's this statue of an eagle or one of these wild animals. These things are sometimes consistent with traditional rulership. So there's an eagle or some Adinkra symbol that has been carved some way, like a statue, somewhere on the wall or somewhere in the yard. You can move it away. Is it a fixture or a chattel? The degree of annexation may classify it as a chattel, but if you test it with the purpose of annexation and you look at the surrounding situations, the reason for which the person wants to use the facility, that object will not be a chattel, but it will be a fixture for him. So that is the point that we want to gather. So in this lecture, I think we'll be very thorough. We'll explain what land is. We've explained from the Black's Law Dictionary the definition of land. And we've also mentioned the differences between a fixture and a chattel with the relative test. Let's do a quick review of what we've discussed under these fixtures and chattels. The review. If an object is affixed to land, such affixing may mean it is a fixture, but not necessarily. Equally, if an object is not fixed to the land, but not necessarily, it's a chattel. So you got that. So the first point of the review is that if it is fixed, generally we will call it a chattel, but not necessarily, because we need to use the two tests. It could be the degree of annexation, but that cannot be the sole test. If we test it with the purpose of the annexation, what originally was a fixture could be construed as a chattel. So if, for example, you went to buy someone's house and the person was disabled, disabled people, sometimes in their house, they have these guarded rails along their stairs that allows them to grab and rise it up. And you go there, respectfully, an able-bodied man. Now, that metal rail that was attached, you as an able-bodied person, do you still need it? It is not. So for him, it was a fixture. It has been permanently attached. But the purpose of annexation was for somebody who was disabled. Now, an able-bodied person comes in. Does he need that? He wouldn't need it. So the purpose of annexation for him now will disable that from being called a fixture. It becomes a chattel, so he can take it off. Hope you're okay. So that's the first point of the review. Let's consider the last part of the review. A party can intend an item to be a fixture, and this will be inferred from the surrounding circumstances of a case. A court will look to see how items are ordinarily used, and this idea of ordinary use can to an extent displace the idea of physical annexation. So the point is clear. So the court will look at the surrounding circumstances. So guys, that's the point about land and fixtures and chattels. Fixtures, we are saying, are the ones that ordinarily we find them attached. Chattels are the ones that we can take them away. But the surrounding circumstances and the inferences that we will see from the parties who are involved in this use of the immovable property, landed property, will help us to decide definitely and conclusively which of the objects that are involved we call them chattels or fixtures. I hope that is clear. So the key point for us is that if in practice you are going to buy a property, make sure you are sure, and I repeat, make sure you are sure what is a fixture and what is a chattel. If you're a student in your upcoming immovable property exam, or you are preparing for the Ghana School of Law entrance exam, make sure that if there are objects that a person in the question, they are saying the person is desiring to sell a property, and maybe there are complaints of the person pulling down items here, left, right, center, you ask yourself, in which category do those items fall? Are they fixtures or chattels? It will help us to be able to pass our exam, and it will be very easy for us to take in key decisions with this. Thank you very much for joining us on this particular session of land. Here is where we bring an end to lecture 2 of what is land. I repeat, subscribe to our channel on YouTube, Supreme Law Publications. Invite your other friends to also join. Share the link with them. Visit our website at www.slpghana.com. You can also reach me there in our offices across the country. Stay tuned for our next set of videos. Catch you.